Ladies and gentlemen, welcome to the course on the Constitution and Public Administration, Law and Policy that is being offered by the National Law School of India University, Bengaluru. You would notice that this is a 12-week course which would be divided into 3 parameters of our discussion. First, of course, we would be dealing with the Constitution of India, trying to understand the basic principles of constitutional governance in this country. We are probably going to have 4 weeks of a discussion, deliberation on the significant aspects of the Constitution that affect public administration. We would be discussing about what is the framework of the Constitution, what are the responsibilities of government, both the legislature, executive and the judiciary. Of course, I think looking at the various aspects and role of certain constitutional authorities is a critical component of public administration. And hence, constitutional authorities, including our local self-governments, maybe it is the Comptroller and Auditor General of India, Election Commission of India, and others, will be keenly discussed and deliberated. I think, the Constitution is as good as what its people would want it to be administered with. And hence, following Constitution is administrative action. Because what is written in the Constitution has to be administered. And hence, the role of the administrative agencies, as we would want to call it, would be probably taken up in the next segment of this course. Interestingly, administrative law, as we would want to call it in legal scholarship, is all about the principles of administration that one has to follow. Of course, every administrative action is subject to judicial review. That is the check and the balance. We know that the Indian judiciary is the watchdog, the custodian of the Constitution, and hence judicial test of administrative action becomes a very important component of this course. Of course, you will also notice that the course has a interesting chapter dedicated to delegated legislation. Of course, the fact of how and what is delegated legislation, what is the purpose of delegated legislation, and what are the controls for delegated legislation will also be taken into consideration. Moving forward, this course will look at administrative tribunals, as there is a phenomenal growth of administrative tribunal in the country. They are sometimes called as administrative tribunals, sometimes they are called as quasi-judicial tribunals, sometimes they are also called as constitutional tribunals as well. So the functioning of the tribunals and their contribution into public policy will be also seriously taken note and consideration of. Finally, the course will also deal with public policy in administration, which is the first topic that I will just try to introduce before I come to the technical topic of the Constitution of India. Public policy, I think, is an important component of public administration, and the nature and scope of public policy in India is actually at a crossroad currently. And I think it's important that the various aspects of all kinds of policies, be it welfare policies, which can be social in character and nature, fiscal policy, or what we call as economic policy, which is so very core and important to a developing economy like India, or maybe the political, strategic and defense related policies that are also critical for the growth of the nation will also be taken due note under this course. Finally, I think the course will conclude on the need for regulatory authorities. As we have seen in India, that the public policy dimension in this country has been governed through the dimensions of some regulatory agencies that have been brought about. And I think over a period of time, thanks to the Indian judiciary and the Indian democratic principle, these regulatory bodies have actually become autonomous to a larger extent. They have become independent and they have contributed significantly to the growth of policy making in this country. To name a few just right now, we can take the important role played by the Reserve Bank of India. The Reserve Bank of India is the central bank. The Reserve Bank of India is the custodian of all financial matters for the central government. But the Reserve Bank of India has been laying down some very important critical policies from time to time for the financial governance in this country. And I think the finance policy of the nation is very stable, as we have already seen that there are many economies that are getting into recession or are on the verge and threat of recession, whereas thanks to the policies of the Reserve Bank of India, which is a deemed autonomous independent organization, has been able to keep stability in the country. Also, we should look at, probably as an example, the policies of the Disaster Management Authority, because India is quite vulnerable to disasters and climate change and climatic issues. We have a serious issue with the Himalayan mountain and the disasters that occur over there. And we also have seen unprecedented rainfall, unseasonal rainfall, extreme weather events, including cyclones at both the coasts of the Indian territory. So this is how the course is being structured and this is how the course is being managed. And I'm sure you will notice that the faculty of the National Law School will be taking some of these topics, and it's a team in the Center for Environmental Law Education, Research and Advocacy at the National Law School, which will be actually leading this course and dealing with some of these topics. We believe that this course will be very, very useful for students of law, students of public policy, students of public administration. We also believe that this course will be also relevant for anyone who wants to do either central or state civil service examination. But I believe that this course is more on the legal literacy part of understanding the Constitution and the governance framework that has been established by the Constitution of India. Moving forward, friends, laying down the context of this course, I believe that, a lot of people would say that to get or write a constitution is the most easiest part. And I think 70 years back, when India got its status of being a republic, we got independence from the Britishers, and we the people, gave ourselves a constitution. I think we did the easiest part, that we said, look, the governance framework in the country will be governed by a written constitution. So the Constitution is the fundamental law. It is the law that actually gives powers to all the three organs of the government. Rather, it gives power to all agencies of governance. The Constitution is the basis of governance. Without the Constitution, probably the country has no governance framework. And hence the Constitution gives that kind of a framework. So framing of the Constitution probably is slightly on the easier part. But what we have experienced in the last 7 years is looking at the working of the Constitution. And that is the real framework of the course that we are going to speak about. So we are not going to give you the text of the Constitution, because I'm sure that is something that you can read and find out. And I'm sure as students of social studies in schools and colleges, you already know what is there in the Constitution. But what is constitutionalism? Constitutionalism, friends, is the concept of the working of the Constitution. It is putting the Constitution into practice, and it is testing the Constitution as it works among the people that it was made in the initial time to govern. So, running the Constitution, I am sure most countries have faced challenges and difficulties, including the United States, where we have seen that though the Constitution of the United States is a small, brief and a crisp constitution, though the United States Constitution can be said to be one of the oldest constitutions in the world, the working of the United States Constitution has seen many ups and many downs as well. Currently, as we see in the United States, there are two political parties, the Republicans and Democrats, and the Supreme Court is also equally divided between the political ideologies of the judges, which probably is not the fair aspect of public policy in the Constitution. And hence, I think world over, countries have realized that running the Constitution is harder than framing the Constitution. And hence, the agencies that run the Constitution, primarily, friends, the agencies are, say, the political body, the legislature, the executive body, the administrators, and the judiciary. But these are not the only agencies that run the Constitution, friends. There are a whole lot of other agencies in public administration that actually lay down the framework for constitutionalism. Constitutionalism is the spirit of the Constitution. It's not only adhering to the text, but the spirit of it. Because the constitutional framework in India, friends, looks at democracy as a principle of constitutional governance and a principle of public administration. Interestingly, friends, I have probably used the term public administration on numerous occasions already in the last 10 minutes. To be honest, friends, let us try and look at public administration in Constitution as the starting point to this course. Let's try and understand the word public policy or public administration. Friends, when I use the word public, what do I mean by the word public? Friends, a public policy, a public administration, a public governance. The word public is something very critical. Friends, the term public is to be understood opposite the word private. What is private is confined within four walls. What is private is confined in terms of secrecy. What is private may be opposite to transparency or accountability. What is private is within someone's own domain. And what is private is not my neighbor's business. So the term public very clearly would entitle a starting point of our debate in this course of saying, look, if my actions stay within myself, then they are private. But if my actions are affecting anyone outside me, that may include my immediate society, it could include my community, it could include the state, it could include the country, then what I do is a matter of public policy. Interestingly, friends, when we talk about public policy as against private, you will also notice that it's also about, say, understanding public in the character of what we call as public resources. Let's take the instance and the example of what is public ownership of public resources. For example, friends, let me give the instance of water. For example, friends, if I am doing rainwater harvesting and keeping the water or storing the water within the four walls of my house, then the water resource is a private resource under private ownership. How I use that water, whether I waste it, whether I use it, or whether I sell it, probably may not be within the domain of public policy. The last part of sale will still be, but I'm just saying in terms of ownership of a resource, it may be considered to be private. However, please note today, as a matter of public policy, please understand and appreciate, we have said that groundwater is a public property resource, and hence we need a public policy for governance of groundwater. Now, let us just take this into a little bit more detail, because you must understand why and how the intervention of public policy under the framework of the Constitution is a necessity, and why public administration, say in water governance, becomes an imperative factor. Friends, before 1974 in India, probably we did not need a law on water, because water was a free commodity. Everybody could have access to the water, and I think you could use the water in a wise use doctrine without actually misusing the same. But unfortunately, in 1974, India brought in a legislation called the Water Prevention and Control of Pollution Act of 1974, where he said that if anyone decides to pollute the water, he shall be held liable and responsible. So while you can keep water, there is a duty casted upon you through public policy and law that you cannot contaminate or pollute water. Now, you would assume that why should this law or public policy mandate be introduced against the activity of pollution of water? Very simple, friends. Water pollution, if I do, is not going to really be effective to me. It may be effective to the community at large. So from a private domain, pollution becomes a public policy dimension. And hence, a public policy dimension of an action that can affect anyone else apart from me, be it my neighbor or be it the community, be it the country, then becomes an actionable intervention of the government. Let's take groundwater for that matter. Friends, over a period of time, I think we all thought groundwater is a private resource. Of course, we had a British era legislation which said that yes, this can be covered as a right of easement. This is called the Indian Easement Act. Now, interestingly, friends, those who have read the easement law will very clearly tell you that easement is only the right of use, not the right of ownership. So you can use groundwater as much as you need, but you cannot abuse beyond a particular period of time. That itself was the public policy that was laid down way back in 1882 by the Britishers. So right of use is different from the right of claiming ownership. So you will notice that in water itself, why should we have, say, interestingly friends, you will notice that the central government has enacted 3 national water policies. Yes, the latest was enacted in the year 2012 as called the National Water Policy. And interestingly friends, you will notice why should the government come up with a national water policy? They should come up with a national water policy for several reasons. First and foremost, please understand, water is under the state list of the 7th schedule of the Constitution, which means water governance or legislations on water can only be made by the state government. Of course, in a country like India, where we talk about unity in diversity, you will notice that governance of water may also be quite diverse from state to state. And water is actually a national resource in one sense, because India unfortunately has what we know as scarcity of water. Please note friends, as a country, vis-a-vis the kind of population that has to look at the carrying capacity and the water equity that has to be managed in terms of water governance, please note India is a water deficit nation because of the huge population that we have. Though we have some sources of river water, fresh water, we are still a water deficit state or a country when it comes to per capita consumption of water. Having said all of that friends, you will notice that the central government wanted to bring a unifying policy among the states. Now the central government cannot make a law. Yeah, it cannot because it's in the state list. State governments can make a law. But can the center bring about a vision document on the use of water or on the prioritization of water use by making a public policy regarding water? You will notice friends, while water is mentioned in the Constitution, it has been mentioned in several parts friends. For example, we talk about interstate river water dispute. Article 262 says that anything that is interstate is within the domain of the central government. So Constitution mentions it. But how have you seen the constitutionalism of water? How have you seen the working of the Constitution towards water governance? Friends, that is precisely what this course should do. That is what you should get an idea about. Look, over a period of time, as the mandate of the Constitution says, that the central government has constituted a lot of these interstate water tribunals. Why did they constitute interstate water tribunals? Because they wanted to resolve amicably any kind of dispute on interstate water, say between a state like Karnataka and Tamil Nadu in terms of Kaveri river water. And hence friends, the water policies of the national government laid down some very interesting and very important principles which can be judicially adjudicated. For example, what is the judicial adjudication on water prioritization in terms of use? You will notice that the national policy very clearly says that in terms of water use, the first use should go for drinking water. Yes, that should be the first use. So wherever you have, this dilemma of what should the water be first used for, please note the national water policy says drinking water should be prioritized. That's the first thing. Second, they say after drinking water, you can look at it from an agricultural perspective. From an agricultural perspective, you can look at it from a commercial perspective. Though agriculture sometimes can be commercial. But you can make the prioritization of water as it required whenever there is water deficit or deficiency of the quantity and quality of water, then prioritization use doctrine has to be used. And finally, water can be used for industrial purposes. So I think the water policy in India very clearly displays the need for governance, the need for constitutional framework to run a country in which there is deficient amount of water. So friends, this is precisely why we require public policy on water. Because water, as you see in the Constitution friends, for example, if you read Article 39, B and C of the Constitution, you will notice that we have very clearly given in the Constitution that the ownership of wealth cannot be concentrated in the hands of a few individuals. This is probably the theory of socialism. This is the theory of equitable distribution of resources. So in India, we do not allow ownership of resources in the hands of few individuals, including water. Water is a resource. And ownership has to be equitably distributed, because that is something that we cannot allow as a constitutional principle to go about. So having laid down this context of water, friends, I think you understand right now why constitution, public administration and public policy are interlinked or intertwined. Because what is written in the constitution has to be brought about in terms of a policy, and what is stated in a policy has to be administered, so that, please note, that water disputes, water war and any kind of communal or any kind of conflict in the society can be avoided. And water, which is so essential for life, without water there is no life, right? Without water there is no state, without water there is no governance, without water there is no constitution. You will notice then the public administration clearly knows how to prioritize water, where to give it for the first use, how to govern water, and that would lay down how the constitution actually deals with the right to what I would call as a right to water. Interestingly, friends, right to water has been held to be a fundamental right under Article 21 of the Constitution of India. If some of you would want to refer, it's called the F.K. Hussain versus State of Kerala case. So, it is a right, okay, under Article 21. It's a duty of the state under Article 39B and C, because 39 is on the chapter of directive principles of state policy. It is a constitutional framework about how to resolve interstate disputes on water, and hence the central government's policy on water lays down the public administration that is required in water governance today. Now, just giving you a dimension, friends, if I can just also state, if you just kind of scan public policy, or how has public policy shaped in India in the last 23 years. I am talking from the year 2000. We are right now in 2023. Just to give you some light on public policy dimension through legislative intervention. Please note, public policy dimensions can be brought about through executive intervention. It can be brought about through the intervention of the judiciary. But how does public policy get shaped vis-a-vis the parliament or the legislative dimension? I'll give you some instances and examples so that we know where we are in terms of the working of the constitution. Friends, let us take a few legislations as an example. Friends, in the year 2002, the parliament enacted a very important legislation creating a regulatory agency called the Competition Commission of India. We enacted what is known as the Competition Act. It has been amended a couple of times. We brought in an agency to actually look at fair competition in the market. Now, this agency has laid down some very important public policy dimensions about how should competitors behave in a market situation. Interestingly, friends, please note today, because thanks to the population that we have in this country, like China, I think one of the biggest markets for consumer goods is India. One of the biggest markets. Right? It may not be for luxury goods, but we have a huge market potential. Now, when market potential is there, when there is more demand than actual supply, naturally the suppliers tend to exploit the market with unreasonable, unfair practices, trade practices. Prior to the competition law, we had a legislation called the MRTP Act of 1969, Monopolistic Restrictive Trade Practices Act. That was replaced by the Competition Act. Now, the MRTP Act actually in 1969 did lay down that monopolies are not good for any market, because monopolies or monopolistic suppliers, producers or manufacturers tend to dominate the market, they tend to exploit the market, they tend to make unfair profits in the market. Secondly, restrictive trade practices. When you restrict, you actually restrict your competitors from entering the market. So there are so many barriers that you impose in terms of cost, in terms of quality. So I think the MRTP Act was good for the time it was, but the competition law was necessitated because India entered into the World Trade Organization agreement, GATT, TRIPS and so on and so forth. We opened our market for foreign direct investment, foreign companies to come and make in India, invest in India. A lot of imports were permitted, and local industries and imports were actually in a conflicting situation at times. And hence, friends, I think to ensure fair competition, but most importantly, don't forget, friends, the competition law's main effort is to not only ensure fair competition among the competitors, but it is also to protect consumer interest, which is the welfare of the citizens, we the people. And hence, friends, you will notice that there was a very interesting public policy dimension. Though we don't have a perfect competition policy in this country, but the competition law was, I think, a legislative intervention, a landmark intervention brought by the government in 2002, and I think it laid down a very important parameter for public behavior of these companies, manufacturers and producers in terms of how market access has to be done by them. Of course, friends, we brought in a legislation called the National Food Security Act of 2013, which is another interesting act on public policy, because in India you talk about right to life, but we have not talked about right to food adequately enough. Hunger deaths due to malnutrition were not uncommon in India. Nutrition and food was scarce in some of the regions. We have heard about Kala Handi and so on and so forth. These are episodes where food was actually a problem and an issue. Now, to address this right to food of every citizen, minimum basic food to sustain and live, I think the Food Security Act was brought into place, but with multiple other objectives to actually fulfill. Because remember, friends, food security is not a citizen-centric approach. The word security, if you just attach significance to the word security, it means it has strategic and security attention as well. Food security means that India must be first food sufficient, self-sufficient. We cannot depend upon imports. So we have to look at green revolution. We have to look at sustaining the population and giving them enough resources to actually have good food. And remember, if India goes to war with either Pakistan or China, food security becomes a critical factor, because then imports cannot be something that you can rely on. So food security in the broader context, please note, not necessarily in the context of the Act of 2013, would mean multiple dimensions about how the state must plan, especially in extreme circumstances when there is a strategic or a security intervention. Two, it should also plan for unprecedented, unseasonal rainfall. Because even today in India, friends, our agricultural economy, I think, at least to the extent of 30 to 35% is rain dependent. Most of our agricultural produce are depending upon good rains. If there are good rains, even you notice that, the business standards, the economic times, they're all saying good rains means good economy. Yes, because even today, I think India is an agriculturally dependent economy. So if it's good rains, good economy. If it's bad rains, bad economy. Now, when it has bad rains, my friends, what is the bad news? The bad news is there could be shortage of food grains. And that should be planned in terms of storage. So you have agencies like the Food Corporation of India and others that are actually responsible for ensuring that food is adequately available, not only for the civilian population, but also for the defense population if it's required. So I just thought I should give you two very important examples of legislative interventions in public policy that have happened in the past 2 decades, which I think have laid down a very important dimension to constitutional governance in terms of the rights of citizens, but also establishing the duties that are there of the various agencies of the government. Do not forget, friends, from time to time, I think the international community has played a very central role in not only maintaining democracy in various countries or strengthening democratic principles in various countries, but also laying down certain kind of goals, including what we call as the SDG goals or what we call as the MDG goals. Now, Millennium Development Goals, as has been fixed by the international community, very clearly displays that a lot of public administrative and public policy intervention have to be strengthened in India. The millenniums have their own goals. The country has to look up to the aspirations of fulfilling the same. And hence, friends, we have to look at a different dimension of public policy in this country. And just to, conclude the introductory part, I would say that there are 6 principles that are important for this course on Constitution, Public Administration and Public Policy. What are these 6 principles? First, I think in India, it is critical to bring in the highest levels of transparency and accountability in governance. The Millennium Development Goals actually insist upon this quite severely. So any policy must, further the objective of ensuring transparency and accountability. Not to forget that we already have a Right to Information Act, which to some extent ensures the same. But I think the next generation of reforms in right to information has already arrived. I think we must strengthen the right to information movement, and I think we need to actually look at transparency and accountability. See, friends, these two are different words. Accountability is not in terms of just giving information. That's probably ensuring some kind of transparency. Accountability in terms of fixing responsibility on who should actually do what, and then imposing adequate liability in case those are not actually fulfilled. So accountability in India has been a huge issue. Government accountability, even the accountability of the private sector has been a critical factor. But I'm sure in the course of this discussion that we have, we will try and evaluate the current positions of transparency and accountability, and we will probably take it further in terms of what has to be done next. Second principle of public administration and public policy is, friends, participation. Remember, friends, we are in a democratic nation where the people have to decide what should be their policy. Now, various policies, friends, there may be, some of them are controversial policies, some of them are policies that can be straightforward, you can actually arrive at. But, how should the policy be made? Friends, generally there are two kinds of, theories. One is called the top-down approach, where the policy is just made by those who have the power to make it. One is the bottom-up approach, which is the truly democratic way of actually doing the policy. Participation ensures the democratic process of policy making. When the constitution itself was made by we the people, shouldn't every other policy in the constitution also be made after due consultation of stakeholders? I think this is precisely what we talk about accountable government, which is also a participatory government. And I think participation is not a mere tokenism, it is not mere lip service, it means real participation, it means actual participation, it means a democratic process where everyone has the ability to voice their concerns, and the government must listen to the concerns of those who may be affected either positively or adversely by that kind of a policy. The third principle, friends, is the principle of pluralism. Pluralism, friends, is actually important because we are a country that is quite divided. And I would not like to use the word divided, but we are divided by religion sometimes, we are divided by caste sometimes, we are divided by ethnicity, sometimes language divides us, geography, northeast to this. I think there is a lot of division in this country, which I think we need to unify. Now, I think it's important that the political process in this country uses the power that it has, or the power of influencing these people that it has, to actually unify. So the kind of pluralism that we have in the country should be used as a strength. All our different interests, or the different lifestyles, or different convictions that we have, or the kind of different diversities that we have, I think those must be used as our strength in the governance framework, rather than using them as weakness. So I think the pluralism principle is a very effective principle in India. I think it has worked in the past to a larger extent, and I think it increases the democratic value in this country. It really strengthens the very conviction of this constitution, which tries to look at unity in our diversity. The fourth principle, friends, that is very important is the principle of subsidiarity. Subsidiarity very clearly states that the central government should usually perform its function with or in association or in partnership with the local administration. So, friends, there is a very interesting saying which says, think global but act local. I repeat, think global but act local. Friends, inevitably in India, because we are so diverse, we are not talking of India being a union of states, we are talking of India being a federal state. Centralization is quite strengthened in India, be it taxation matters, finance matters, or governance matters. I think the parliament is quite strong, and I think the framers of the constitution, or the fathers of the constitution, wanted the central government to have that kind of strength. So the central government being strong, You have seen in the past that a strong central government can be good for the country, it can sometimes be bad for the country, as we have seen in the imposition of emergency, because there can be abuse of that power as well. But while the good and the bad can be discussed, I think it's very important that as we go forward, yes, the central government should have all the powers that it has, even those powers of residuary character in nature. It should have the powers to bring a law to give strength to international agreements, as we have seen in Article 253 of the Constitution. Nevertheless, I think the government in Delhi cannot be an effective government unless it has foot soldiers in the local government. So the spirit of the 1992 73rd and 74th Amendment should be an effective spirit that the central government ought to follow. So local government and local governance is very, very important, friends. That is where people see governance, people see administration, people see public policy. So the top-down policy making could be fine, but it should have local sensitivity, local issues, and that kind of subsidiarity principle is something that should be governance principle in public administration as well. The fifth and the sixth principle, friends, are principles of effectiveness and efficiency of public administration. Of course, this cannot be compromised at all. You can have the best of regulators, but if you don't have the best of men manning these regulatory agencies, I think efficiency and effectiveness of public policy and administration are going to be adversely affected. And hence, friends, today as we speak, in the post-globalization era, where there is a reverse of globalization, I suppose, there is so much of nationalism as against globalization, I think it's very, very important that efficiency and effectiveness of public administration and public agencies are insisted upon. I think performance-based appraisal are the next method of public administration, if you would want to call it. The final principle, friends, for public administration, I would say, is equity in access to services. Friends, I think it's important that even today, as we speak about, many of the services that a citizen actually realizes is either directly through the government or it is indirectly from the government. And hence, equity in accessing all these services and goods, I think, is a very important principle of public administration. When I say equity, friends, it does not mean equality. It means equity as one deserves. He should be entitled to those kinds of privileges, those kinds of resources from the government. I think the government should realize that development parameters of public administration. Now, this is very important, friends. It's not about social parameters, developmental parameters. There are so many aspects of development that every citizen would like to enjoy. I think equity should play a very critical role. So you cannot have disparity of development, say in a northeast region to a Uttar Pradesh region to a Tamil Nadu region. So access to service and equity are the effective institutional principles of public administration. So if I can just recollect the 6 principles, just as we close this first introductory aspect, I'll just tell you those 6 principles are: first, transparency and accountability; 2, participation; 3, pluralism; 4th, subsidiarity; 5th, efficiency and effectiveness; and 6th, equity in access to all kinds of services from the government. So these are aspects that public administration has to govern. So what I've done, friends, is to lay down the context of this course and context of public policy in the Constitution, and I think we should from here take on and take it further as well.